Welcome to SST College of Arts and Commerce. This is SST Edupedia. Myself, Assistant Professor Sunil Shah. Today I will be covering up the topic called Design Act, which is in the subject called Business Law. And this particular topic is there in FYBMS in the Sem 1, and the unit is covered as Unit 4. And under the topic, under the class called SYBCom, which is there in the Sem 4, and the unit which is mentioned under for the design is Unit 5. The subject is common for FYBMS as well as for SYBCom. Today I will be speaking about the very important topic under intellectual property right, that is called design. How the design has to be registered under the Design Act and the complete procedure of registration of design. Coming to the Design Act 2000, students, please remember, in every day-to-day life we encounter with various objects which can be recognized by the observing the design. There would be a design of camera, would be a design of laptop, or design of the motherboard, or the design of any of the capsules or any of the product, whichever is there in the market. Whether it will be a design of the MRI or CT scan machine, or it will be a design of any of the lenses. Products which are artistically designed can grab the attention of the customer the moment they see it. Hence, the students, the peoples, the manufacturers go for the registration of the design. This design can take the form of art, drawing, or the graphics. The designs may be created by professionals who are very good in profession, like architectural designs, which include engineer designs or architecture blueprint of the particular the layout of the plan of the buildings or the sites, or any properties or the interior designs. So as to bring the design into legal formalities, the Indian government started with the incorporation of the Design Act in 2000. Presently, design laws are maintained by the Design Act 2000 and Intellectual Property Act. Intellectual property rights, under intellectual property rights, design comes into one of the criteria. Intellectual property law in India covers the rights related to trademark, copyright, patents, and now the designs as well as the geographical indications. The basis of the act is that first who has filed that particular design, who has registered that design, they would be getting the privilege against the other person. This system, which means the innovator or the owner of any design should file an application to register the same as soon as it is possible to prevent from the piracy and for claiming the certain rights over the particular design. Now coming into the silent features of design under the Design Act, India was a member of the World Trade Organization in the Paris Convention. Under the Act 2000, the Lacrano classification has been adopted by India, which has the classifications based on the subject matter of the design, whether that particular design comes under the garments, or whether that particular design comes under the motherboard or the PC, or whether the design comes under the category of watches, or the design would be coming into the category of the bottles, or would be in the cases of watches. Under the previous provisions, the classification was made basis on the material, now which has been introduced to make the material. Previously it was based on the material, now it is based on that particular category. So this is the difference between the previous Design Act and the current Design Act. The introduction of absolute novelty, which is new and unique, makes it possible to judge a novelty on the basis of the publication of an article which comes under intellectual property rights. What are the advantages of designs registration in India would be informed in this particular slide, that the particular person who has registered the design is the exclusive owner of the new and original design. He has an asset of the or a proprietor of the particular design. He can initiate legal proceedings against that person who has infringed that right or who has copied that particular design by the third party, and whether there is a prima facie evidence in that to file an infringement suit or against that third party. He has the right to sell, the person who is the owner, he has the right to sell, transfer and license the design with an ease, comes under Design Act 2000. What are the essential requirements for the registration of the design, which will be informed in this particular slide? A design should be original, it should be new design. This means that it should be used or published for previously in any country before the date of application of the registration. The design should be significantly distinguishable from the known designs or the combination of the known design. So it should be something different. The design should not compromise any scandalous or obscene matter which is not allowed in India. The design should be mere a mechanical contrivance is also permitted in specified cases. A design should be applied to an article and should appeal to the eye, which is catchy. That should be uniqueness of the design, then only it can be registered. A design should not be contrary to the public order or morality, which is not allowed or permitted in India for registration under the IPR, that is under the Design Act 2000. Coming to the purpose why this Design Act was been incorporated, design is of type of IPR, that is intellectual property right, that protects the combination of the two-dimensional or three-dimensional of the lines, patterns, shapes or the color. So this type of combinations can be also allowed for registration under the design, that the concept should be proper, then it should be creative design. If you go, it should be much more not copied from the web. The idea should be unique, and then only the process of design would be covered up under the Design Act. So if you see from this particular thing, the first is the concept would be clear, followed with creativity, then it should be applicable in the web, and then would be ideas. So if this particular five things combination is there, then the design can be registered. Coming to the main part, registration, the proprietor of the registered design can file an application of restoration of the lapsed design as per section 12 of the Design Act. So once a design is been registered, and if the person has a registered design and there is a duration has been expired, then it can file a application for restoration of the design under section 12 of the Design Act, and it is the registrar or the controller who decide whether this particular design which has been expired should be given an extension. The application for restoration of the lapsed design should be filed within 12 months from the date in which the registration of that particular design has ceased its effect. So the rule for that is that if a person can go for restoration of that particular design, or provided that he has filed an application within the 12 months of the expiry of that particular period of the registration. Coming to the what is considered to be registered under the Act, that is Design Act, the work should be capable of selling and made separately. It should be original and new to the market. It should be purely distinguishable from the other design. It should not relate to obscenity of or any material which is inappropriate, then only it can be registered, or it cannot be registered. Coming to the various registered designs which we can see from this particular image, the bottle of the Coca-Cola, which has a unique design of the bottle, that particular design has been registered. This particular types of shoes of the kids which was common, that has been registered. The two knives which are shown, the forks which have been shown, which is having a uniqueness, has been registered. There are other designs of Unilever, the Shell, Petrochem, the Federal Express or the IBM. This particular design combination of the lines, patterns or the colors are being registered. And if you see, there would be different types of bottles like Aquafina or Bailey or any Bisleri bottles or any Tupperware bottles. There has the uniqueness of the designs have been registered under Design Act 2000. What are the eligibility criteria for the designing? Any person or a legal representative of that particular person who has created the design, or the assignee of that particular, can apply separately or jointly for registration. The term person may include the person, individual, a firm, a partnership firm, or small entity, or a body, corporate or company can go for registration of that particular design if it is his own creativity. In case of non-resident Indian, that is NRI, his agent or his legal representative need to apply for the registration of that particular design. Comes under the intellectual property rights. Now coming to the compliance process, as the policies which are there, it should be periodical up to the law. There should be fill up the requirements which should be necessary for registration, followed with the rules they should obey. There should be standards which are being framed by the controller, has to be complied with. There should be the governance of that law, or should be abiding that the law, and there should be regulation followed with the transparency in registration of the design. Coming to the documents which are needed for the registration of the design, should be a certified copy, that a self-certification should be given by that particular person who has created the design, that is the actual owner. Then that particular document would be, as a disclaimer, he should mention that no other, it has not been copied from some other website, or it is his own creativity, that should be mentioned in that particular letter. that is called a certified copy of the original, he is the original person. That should be supported with an affidavit signed by the notary on the stamp paper. That should be also a declaration that it is his own creativity. There should be other, it should not be in the other public domain, and there should be public document which can be made available on the payment of the fees. So this particular design can be made available to the other person to view that this particular design has been registered, provided he has paid the fees to the IPR office. The affidavit should be in paragraph and should contain the declaration of the truth and verifiability, that is verifying that whatever is mentioned in that particular affidavit is true and best of his knowledge. However, the control may regulate the cost involved in the design registration according to the 4th schedule under the Design Act. Coming to the process, if you see from this particular slide, there should be the application should be filed by the person who has created the original design, followed with the, there should be examination report by that particular controller, followed with the controller response. The controller will accept that particular design for registration, or he may reject. If he is rejecting, he should give the reason, sufficient reason why he is rejecting that particular design, not fit for registration. He should, and the person who is applying, he should go again for correcting that particular defects, and he should can apply once again for registration. The design, after the correction is being corrected, the design would be going for publication by that particular controller, and followed with the design registration. The design can be registered under the IPR office under the Design Act. Coming to the next procedure, same way it should be A would be filing of the application by the person who is created design. There would be examination report by the controller, followed with the controller response whether he is accepting or rejecting with the sufficient reasons. Then there should be publication in the official gazette that design is been published, and there would be registration of the design. So it can be of CFL bulbs, or it can be of the any of the bulbs, or any of the instrument, or any of the watches. Coming to the registration of design, the first thing is to be noted that the application of the register may be applied at 5 different locations. It would be the controller office, is the patents. In the patents office only the design can be registered. So there is no such other different office of design, and so no such a different office of patent. In the patents office only design can be registered. The office of the patents are in Kolkata, Delhi, Ahmedabad, Mumbai and Chennai. So in these particular areas, the persons who are residing, then they can go for registration of their design. What are the procedure for the design? The application of the design registration must be filled in the form 1, which is uploaded into the website of IPR. The name of the applicant, the address of the applicant, the nationality of the applicant, why we require the nationality, whether the law is applicable to the Indian national or the foreign national. In case of company, information relating to the place of incorporation, that is where the ROC had issued them the certificate, and the legal status of the entity, whether it is LLP, partnership or a company, private limited or public limited. The required fees payable has to be mentioned along with the particular form. The class and the subclass of the article under the Lacrono classification is based on the particular category, not based on the material which is used, and the article embodying that design. The name and the article to which the design is applied upon, and the representation of the design. So this is mean about the procedure of the registration at the patents office. Coming to the second part, in this case where the design is 2-dimensional, the 2 copies of the design is to be submitted. When the design is of 3-dimensional, 2 copies of the designs of the viewpoint from the front, back and the top and the bottom, as well as the 2 sides must be submitted in case of 3-dimensional figures. Further, the application must also highlight the unique feature of the design that it sets the part of the other existing designs. If the application is to register the design of more than 1 class, each class of the registration must have a separate application, and the separate fees has to be paid. After the submission of the application, the patent office will examine the application and raise the objection, as I informed in my earlier slide. If upon the clearance of the objections or removal of the objections, the designs may be granted and a copyright certificate may be issued by patent office. The patent office, as I said, it may be of Calcutta, Delhi, Ahmedabad, Mumbai or Chennai. Coming to the main part, that is what I like to inform you under the IPR, that is trademark, patent and copyright. The duration of the copyright is that the lifespan of the author or plus 70 years. In case of patent is for 20 years, and in case of trademark is as long as the trademark is used in commercial transaction. Under the trademark, what is protected? Any word, phrases, symbols or design that recognize the differentiate shows of one of the parties which is good from that of other. Under the patent, we will speak about inventions such as procedure, manufacturers, composition, machines of the matter, as well as improvement made under this. Under the copyright, what would be protected would be the books, article, music, photography, sculptures, dances, sound recording, motion films, and the original other works of the authors. As you remember, the trademark has been governed under Trademark Act 1999. The patents has been covered under the Patents Act 1970, and the copyright has been governed under Copyright Act 1957. Now, I would be informing you about what are the designs which cannot be registered. The signs, emblems, or the flags of any country cannot be registered. The size of any article, if changed, cannot be registered. The structures and the buildings cannot be registered. The integrated circuits layout of won't be registered. Any trade variations are not capable of registration. Any principle or mode of construction of any article such as labels, tokens, cartoons, cards are not at all registration, are not eligible for registration. The books, normal notebooks, calendars, certificate, jackets, forms of other document, greeting cards, maps, plan cards, postcards, leaflets, stamps, medals, and dress making patterns are not capable of registration. A mechanical contravenance is not applicable. The workshop alteration of the component of the assembly of that particular machine is not capable for registration. Part of any article which is not a manufacture process or sold separately are not capable of registration. So these are the various points where the controller won't give that particular registration of the design if that particular category falls in it. What comes under the, now coming to the concluding part, whatever the duration of the registration, the total time which of the design can be registered is 15 years. Initially it was 10 years, which could be extended for another 5 years by paying an additional fees of rupees 2000 to the controller, but it should not be done after the expiry of the 10 years period. The proprietor of the design may even file for application as soon as the design get registered for such an extension. So this is under the Design Act. The rules which I explained in this particular slide is a Design Amendment Rules 2021. What I spoke was earlier was Design Act 2000. Now I am speaking of Design Act Amendment 2021, that is for 15 years. Initially it was 10 years, which can be extended by paying rupees 2000, where the controller can give an expiry within 10 years. The proprietor of any design may file application as long as the design get registered for such an extension. What are the piracy or what are the problems? The piracy part, in case of civil suit, it is brought against the piracy of the design. The compensation shall not exceed rupees 50,000 for the infringement of any of the design. So if the person who infringes the design or if he copies that design, then the penalty is rupees 50,000. The compensation is actually fixed, so it is serves as a good ground of interim injunction even before the trial of the commencement. So under the intellectual property rights, these are the particular penalties. I am informing about the various the particular designs which are being uploaded into the Designs Act or the website. This is the design of that particular sari which has been registered. If you see this particular figure where the mouse is scrolling, the case of that particular watch has been registered, and if you see, these are the different types of fans of Havells company who has registered this different types of fans. There are 2 wings, there are 2 blades and 3 blades fans which have been registered, which is there uploaded of FAT 2023 journal, which has been published into the IPR. The sari design, which is of one of the company, the case design of the Casio company, and this of the fans designs of the Havells company. Coming to the duration, the trademark duration is 10 years, copyright duration is 60 years, patent duration once it is 20 years, and design is 10 years. Now amendment done is 15 years. Coming to the concluding part, the conclusion, Design Act 2000 brings about any changes which are observed in any features. When the developer develops something, for example, if an architect develops some structure of the building, there is an expectation that my structure should not be infringed, it should not be copied. Many designs are capable of providing the author with the copyright also. So design and copyright gets together also. Thank you from my side, students. In this particular video, you heard, you understood the procedure of designing and what is the procedure which design cannot be registered and what are the penalties under it. Thank you from my side.